There's no one here to introduce us. My name is Jack Blum, and I happen to currently be chair of Tax Justice Network USA, but I'm an attorney and I practice in compliance and in international tax. So I have some background in this, and I also was involved to some degree in the investigation of the case we're going to talk about, which is the Wyly case. And on the screen, I think behind me, is Bob Roach, who was the principal investigator and the man who put together the Senate hearings on the Wyly case. And he has prepared some slides. And the way we were going to proceed was to put some of those slides up and begin a discussion. He'll open, I'll follow, and we'll get into a bit of back and forth. But before we put the slides up and get going on that, I want to sort of set the stage by saying there are critical issues that this case opens up, which every one of you should be paying attention to. The first issue is that, yes, this is a case that involves a man who really, or two men, who really seriously didn't want to pay any tax on anything. But on top of that, it turns out they used offshore for the evasion of regulation, and in this case it was securities regulation. And they were also offshore as a matter of asset protection. And at the end of the day, they used the offshore maze to make enforcement impossible or next to impossible because it was so difficult to gather the information and for prosecutors to move forward. And the fragmented information and the deliberate obfuscation and the delays in doing anything are part of the strategy for the Great Getaway. And I'll mention one other thing, that is the concept of the trust. Offshore trusts today make a joke out of the original meaning of the word trust. In the past, when I went to law school, for a trust to be really a trust, you had to give the money away to the trustee under contract. There had to be definable beneficiaries. The trust had a limited life. And once you had declared the trust and put the money in trust, that was it for you. It was now up to the trustee to run the trust. Since then, we've had jurisdictions competing for how loose the trust laws can be. And this has led to the creation of trust protectors, to jurisdictions such as Belize, where you can be the grantor, the trustee, the beneficiary. You can do the management, you can have a trust protector who says where the assets are to go, and you can change a trust whenever you want. Now, these are trusts which, to my mind, are sham, but jurisdictions are in competition for how bad they can make the law. And, man, it has been quite a competition. But with that, let's move to this particular case study, and why don't we take the first slide here. This is the story of the Wylys. Bob, why don't you take it away, and let's go to the first slide in the PowerPoint.
Okay, thanks, Jack. First of all, I just want to start out with a disclaimer that the views and thoughts I offer here today are my own. They're not reflective or representative of the Permanent Subcommittee on Investigations. What I reference here as far as the subcommittee report, the subcommittee findings, that clearly is the subcommittee's business, but I'm here speaking on my own behalf, and I'm not speaking as a representative of the subcommittee. Jack, if I could just take a minute, you raised a lot of important points that this case study really touches upon, and I just wanted to bring a couple of other ones up too. You know, there are the tax issues. There's a lot of security issues here, mostly revolving around the issues of disclosure. But there are also issues of AML compliance. Bank of America never required beneficial owner identifications for all of these corporations and trusts that were utilizing their facilities. And in fact, in early 2000, Bank of America actually knew who these beneficial owners were through other accounts, and yet tried to play this game that on the securities side they really didn't know who they were. Moreover, I think that this tells a really, I guess, disconcerting tale about how intricate and complicated some of these offshore tax abuse schemes have become, where you have to enlist an armada of lawyers, trust company officials, financial institutions, and the like. And it really does begin to show how very supposedly top-drawer professional organizations are turning a blind eye to this stuff, and they've actually become enablers of these schemes. So if we can go to slide number 2, it's entitled Offshore Trust, the Wyly Case Study.
It's up here. Okay. Go ahead.
Most of you have had a chance to look at it. I mean, it just sort of summarizes the extent of this structure and how long it lasted. Now, I just have it up through the time that the subcommittee did its investigation. Of course, as far as I know, these things are still in existence, and currently it's under litigation with the SEC. 13-year time period, millions of stock options worth $190 million were moved offshore. 120 million of that was untaxed. We were able to identify 19 offshore trusts and 39 shell corporations that were owned by those trusts. At the time we concluded our work, we calculated something about $600 million worth of untaxed stock sales and other investment gains were returned to the Wylys through loans, through investments in their related business operations they set up, and through personal effects, huge real estate holdings, furnishings, art, and jewelry. There is absolutely no question that throughout this entire time, the Wylys have effectively retained control and beneficial enjoyment of all of the assets. And as I said, probably one of the most disconcerting things about this, that the entire scheme was facilitated and structured by professionals.
The excuse being, my lawyer made me do it.
Absolutely, absolutely.
Okay, now we ought to back up.
Just as a note there, Jack, it's very interesting, I think very